Welcome to today's Practice Note debate, proudly hosted by the Turnaround Management Association of Southern Africa. My name is GOTTSCHALK, and I will be the moderator of today's debate. Today's topic is the retrenchment of employees in the business rescue process. We are privileged to be joined by industry experts who will help us understand and unpack this relevant topic. Our first panelist is Mr. Tobie Jordaan of Cliff Decker Hofmeyr. Tobie is a director of the firm's dispute resolution practice and head of its business rescue, restructuring, and insolvency sector. He focuses mainly on business rescue, business restructuring, insolvency, and corporate recovery. Our next panelist is too from Cliff Decker Hofmeyr, Mr. Imraan Mohamed. Imraan is also a director at CDH, but specifically the employment law practice. With over 18 years experience, Imraan advises on all aspects of employment law, ranging from transactions to litigation to compliance. He has acted as a judge of the Labour Court and has vast experience in dealing with issues affecting employers. He also advises across the continent and has been the lead attorney in various precedent-setting cases. Our final panelist is Mr. Brett Abraham of Weber Wentzel. Brett is an employment law specialist with substantial experience in labor and general litigation. He has advised multinational corporations on the employment-related implications of doing business in South Africa, both in relation to compliance with local legislation, as well as in relation to the employment-related consequences of business transfers. Brett too has experience in the mining and metals industry, advising mining clients on all employment law matters. As we jump into our topic today, I wish to give you a brief overview of what we will be discussing. Whenever legal disciplines overlap, interesting scenarios occur, and differences in opinions lead to the arguing and interpretation of what the legislator intended. One such scenario occurs when the employee's rights are affected during a company's liquidation or business rescue proceeding. The employees of a company are normally the last people to find out that a company is struggling financially. Look at the images from Lehman Brothers and Arthur Andersen after they collapsed under the weight of their insolvency. These employees had a mere 15 minutes to vacate their desks without any prior warning. Employees are also often the only stakeholders who are not in a position to negotiate their risk should the company pursue cost-saving measures. A business rescue practitioner needs to evaluate the rights given to the employees during a company's business rescue proceedings, yet manage the rescue in such a way to meet the objectives of the rescue. In the matter of South African Airways versus NUMSA, the Labour Appeal Court considered whether dismissals for operational requirements during business rescue are permissible. The Labour Appeal Court found in this matter that the terms of the Companies Act are clear, and that a business rescue plan must be finalized before embarking on retrenchments. The judgment simply stated that there is no basis in Section 189 of the LRA or Section 136 of the Companies Act to argue that a moratorium on retrenchments during the business rescue proceedings prohibits a business rescue practitioner from offering a voluntary severance package as a measure to avoid retrenchment. In this debate, the fundamental ideologies of company law and labor law will be challenged and examined by our expert panel of guests to attempt to understand and process the available processes available, the difficulties to overcome, and how contracts of employment will be treated in the future business rescue proceedings. My first question goes to Tobie of Cliff Decker. Tobie, thank you for joining us. What options are available to employees when a business rescue commences?
Thank you, Caitlin, and thank you for having me, and thank you for the beautiful introduction. I think that employees have wide-ranging powers and rights in business rescue proceedings. And I think to unpack that is best to first classify the different categories that an employee can have in a business rescue. So firstly, they are an employee of a company. Secondly, they're also treated as an affected person. And thirdly, they're also a creditor of a company in rescue. So right off the bat, and as a starting point, employees have the right and the option to always be informed of all the business rescue proceedings, i.e. the commencement of the proceedings, the appointment of the business rescue practitioner, the first meeting of creditors and the first meeting of employees. Then, of course, as an affected person, they are entitled to apply to court to set aside the resolution whereby the business rescue proceedings had commenced. They can apply to court to set aside the appointment of the business rescue practitioner. But more importantly is that employees have the right to remain employed on the same terms and conditions, with the only exception being changes in the ordinary course of attrition, which includes fair dismissals and VSPs. So to ensure that trade unions and employees are fully informed at an early stage about the circumstances of the company, the business rescue practitioner must further convene a meeting of employees within 10 business days after his or her appointment. And of course, the practitioner must also consult with the employees for or during the development of the business rescue plan. It's very clear for me that the labor law has a very important role to play in any business rescue proceedings. But however, despite the substantial and extensive protection of employees and their interest throughout the business rescue process or proceedings, the definition of business rescue does not make any reference to employees or mention the preservation of jobs as one of its goals. So the reason for this could be that the position of employees is regarded as protected by implication, both in the event that the companies return to solvency and the employees thus retain their employment, as well as in the case of an alternative goal of a better return for creditors or shareholders, which could appear to imply a sale of the business as a going concern, and where employees would then be protected by the LRA.
So you said a few moments ago that employees are both affected persons and creditors. Is that correct?
That is correct. They credit salaries.
So how do the employees then get to vote in this process?
So they vote based on their outstanding claim. They vote in their capacity as a creditor. So they will submit a claim for their outstanding salaries, either pre and post the commencement of the business rescue proceedings.
So it's interesting to consider the employees as creditors, because that by definition implies that they are a cost line on the business. So to Imraan, what options are available to the practitioner to reduce this cost during the business rescue process?
Caitlin, let me try and answer the question like a lawyer, right? And I just want to get back to what Tobie was saying a bit earlier on the substantial protections that are now granted to employees in rescue proceedings. And not because I'm a nerd and not because it's a lockdown and I've got nothing better to do, but the LAC judgment has absolutely entrenched rights of the employees in a business rescue. So I just want to read one paragraph from the LAC judgment in which permeates the security of employment during the course of a business rescue. At paragraph 29, the judgment says that the primary aim of a rescue is not merely to rescue a company business or potentially successful parts of the business. So the LAC says, well, that's not a narrow focus. It says the procedure aims to rescue the whole company or corporate entity, the entire business. And it then goes on to say this will naturally include preservation of jobs. So what has now been elevated during the course of a rescue is the preservation of jobs and keeping as many jobs intact during the course of that process. So that becomes the responsibility of the practitioner. Because, as the court says, indeed, one of the main drivers for the introduction of the rescue regime in place of the system of judicial management was the the rescue of an ailing business, and thus the retention of jobs. So that's got to now be almost the starting point. And all of that gives rise to a number of practical problems for practitioners. And some of that was highlighted in argument in the Labour Appeal Court, but we know where the court ended up on that. So to then get back to the question as to what options are now available to a practitioner who has this obligation to save jobs and to also rescue the bigger business. What does a practitioner do on day one, as it was when he or she arrives at the workplace? I would think amongst the immediate practical steps to be taken is almost a change in mindset, if this was not the mindset pre the LAC judgment. And that is to realize that employees, and particularly trade unions, are an important stakeholder or constituency that needs to be dealt with in a manner in the rescue that will assist to save as many jobs as possible and rescue the business. So that's going to be a change in mindset from day one, I would think. What a practitioner then needs to do is consider the concept of perhaps a voluntary severance package. And Brett can come in on this bit. But the question of a voluntary severance package is not part of a retrenchment. And the LAC makes that point as well in its judgment, that a voluntary severance package is something that can be considered divorced from a 189 retrenchment process. So voluntary severance package is certainly something to be considered. Then another option to consider is short time. And in a retrenchment or in a business that's under immense financial trouble, or where there's not a requirement for employees to be available on a day-to-day basis, the possibility of entering into agreements with employees on short time is something to be considered. Tobie made the point, employment is protected. You can't do anything with employees unless they terminated for misconduct or poor performance, or there's an agreement to change terms and conditions of employment. Short time is a change in conditions of employment, so you require consent from employees. What practitioners need to be alive to is, are there collective agreements with unions that regulate short time? If there are, you need to comply with those agreements. If the business falls within a particular bargaining council, you need to have regard to the terms of the bargaining council main agreement in relation to short time as well. So those are two practical issues that can be considered on day one in order to look at, or is an option available to a practitioner.
Very interesting. Thanks, Imraan. I would like to jump to Brett. Brett, Imraan discussed this topic of voluntary severance packages. What kind of effect does that have on the employee's ability to claim from UIF?
Thanks very much, Caitlin. Generally speaking, a voluntary agreement or a voluntary termination of employment on agreed terms would impact on the ability of the employees to claim unemployment, in the sense that this wouldn't be a termination for purposes of the UI-19 form that would entitle the payment of benefits. That doesn't mean, however, that a business rescue practitioner shouldn't be looking at this simply by virtue of the fact that employees may not be able to claim the benefits. What you should instead be looking at is, when this is offered, is trying to structure that agreement such that the business rescue practitioner gets what is necessary out of that agreement. In other words, an agreed termination of employment and a waiver of claims, but at the same time that the employee gets the benefit to claim unemployment. And how that's often done is by structuring the agreement such that the employee is retrenched. In other words, it is a dismissal. It is recognized as such on the UI-19 form, and that dismissal is simply then coupled with a waiver of claims. So both parties would get what they want. Just to add to what Imraan said, I think over and above the short time, what a lot of employers experienced during the course of the lockdown is the need to immediately investigate ways to change the way their businesses operated because of COVID-19 and the pandemic. And a lot of those experiences included changes to terms and conditions of employment otherwise in short time, reductions in pay, reduced working weeks, that kind of thing. And I think Imraan is absolutely correct when he says the mindset change is necessary. This is the first thing a business rescue practitioner should be looking to do is, where can I cut? How can I cut? And if I need to cut, what are my restrictions, like collective agreements and bargaining council arrangements? There's also the ability to place employees on leave if the contractual arrangements permit that. So the engagement, one would expect the trade unions and the employees to expect, at the very least, that if they're going to be offered a voluntary severance package, that they will be entitled to claim the severance benefits and that the unemployment benefits, sorry, and that must just then be coupled with appropriate wording in the agreement so that there's no comeback in due course.
And Brett, can this process begin prior to publishing the plan?
Yeah, so the Labour Appeal Court has made it pretty clear now that these things can be separate, absolutely de-linked, and there's no restriction on a business rescue practitioner coming out immediately with the offer of voluntary severance packages. It may also be that elder employees are offered early retirement to the extent that the rules of the fund permits. All of those things can be done pretty immediately. Of course, there is a delicate balancing act because you don't want to be seen to be compelling persons to accept either a voluntary termination or making them do so under duress, or more difficultly, or more importantly, if that you're trying to get them to change terms and conditions of employment, you're of course not able to then dismiss if they refuse to accept those changes to terms of employment. So those are delicate balancing acts, but as much as there's got to be a change in mindset of employers, there's also got to be a change in mindset of trade unions and employees. You can't be adversarial in this process because at the end of the day, it's jobs at stake. And the more employees can work with companies by exploring these things and with the business rescue practitioner, the better ultimately for everyone. I think as soon as adversarial processes are adopted and employees or trade unions stick their heels in the sand, well, nobody wins.
Absolutely. So my next question goes to Tobie, which is, if you enter into these kind of discussions with the employees, as we just discussed, and you do it immediately, and then later you find the company does not have sufficient cash to honor that agreement or honor the amount you agreed with the staff member, will you be able to compromise?
It's a difficult question, Caitlin, in a sense that, and I'm glad that you asked the business rescue lawyer that question. It's an extremely difficult question, and a question that I've debated with my colleagues often. The shot that I'll give at the answer is that it depends, and I'm asking for advice from the employment lawyers on the call, it depends on the makeup of that claim, because we must always be mindful of the ranking of claims in a rescue. And how do you then apply the compromise? Because as we all know, that your post-commencement salaries or outstanding salaries post the commencement of the business rescue proceedings will enjoy a higher ranking in the payment waterfall in a business rescue plan. And whether you could then compromise that portion in your retrenchment package in the same manner as you would compromise a concurrent claim pre-business rescue. So I think if it's possible to break up the retrenchment package and the claims that make up or the VSP, then you could apply a potential compromise to it. But I don't think as a whole, you would be able to compromise the entire claim, because as I said, it's made up of different claims that enjoy different ranking in a business rescue.
Thank you for that clever and qualified answer.